Wind Energy, LLC, Article 7, proceeding case 21T0059. We will begin the information session and public statement hearing at 6 o'clock.
Good evening. Welcome to the public statement hearing for Alle-Catt Wind Energy, Article 7, Case 21-T0059. The public statement hearing will begin shortly. If you are experiencing any technical difficulties, call 1-800-342-3330. Again, we will begin shortly.
Good evening, everyone. I show it as 6 o'clock. My name is Greg Sayre. I am the administrative law judge assigned to this case. Before we go into the public statement hearing portion of this call, we're going to have two brief presentations. One from Jessica Shaw of the Department of Public Service staff on the Article 7 process for this case, and the second from the applicant, Alle-Catt Wind Energy, LLC, describing the project. At this time, I yield the floor to Jessica Shaw.
Thank you, Judge Sayre. Share my screen really fast. Okay, good evening. My name is Jessie Shaw, and I work in the Office of General Counsel at the Department of Public Service. Thank you for coming to this public statement hearing for Alle-Catt Wind Energy. This presentation is meant to provide an overview of Public Service Law Article 7, which governs the Alle-Catt Wind project, and it will also include some details of the project itself. So as background, Article 7 applies to major electric lines, which is defined in the Public Service Law as a transmission line with a capacity of 125 kilovolts or more, that's at least 1 mile in length, or a line that has the capacity of 100 kilovolts or more and is at least 10 miles in length. So for context, the Alle-Catt Wind project will involve the construction of a 10-mile, 345 kilovolt transmission line. Article 7 was passed by the New York State Legislature in 1970 and established new facility siting procedures to minimize environmental impacts. And this includes impacts to forests, streams, wetlands, agricultural land, and historic resources. Article 7 also implemented procedures to minimize quality of life impacts, which can include construction disturbances, traffic, dust, electromagnetic fields, noise, or visual impacts. Article 7 also established a forum to resolve issues including the location of the line and matters of local law. So Article 7 creates an open process that involves state agencies, municipalities, citizen groups, and interest groups. Article 7 is not subject to the State Environmental Quality Review Act, or SEQRA. but it does require an environmental analysis of potential impacts of the projects, requires minimization of impacts, and allows for public participation. An entity must submit an application under Article 7, and this application generally includes information about the project, a description of the location of the project, a description of project facilities, reasonable alternatives considered by the applicant, environmental impacts, design drawings, the economic effects of the proposed facility, and local ordinances that may apply to the project. The application must be provided to municipalities, and that includes counties, cities, towns, villages. It also must be provided to state legislators and other state agencies. The application is available online at the link provided on this slide so that the public can view the application as well. Each application is docketed by a case number. So the number for Alle-Catt is 21-T as in Tom -0059. So you can use this number to find the application on the DPS website. And the New York State Public Service Commission, or the PSC, is the decision-making board that's responsible for reviewing the Article 7 application. And the Department of Public Service, or DPS, is the state agency that works for the commission chair and participates in the review of the application as well. And DPS consists of engineers, environmental staff, economists, legal counsel like myself, consumer outreach, and administrative law judges. Along with the staff of DPS and the applicant, parties to an Article 7 proceeding can include the Department of Environmental Conservation, Department of Agriculture and Markets, or the Department of State. Others may join as a party to the proceeding as well by requesting intervener status. So interveners typically will include municipalities of where the line is proposed, residents of those municipalities, and environmental or public interest groups. As a party, you have both rights and obligations. So you are obligated to comply with procedural rules and directives of the administrative law judges, but you also have the right to engage in discovery, present expert testimony, participate in evidentiary hearings and file briefs, and also participate in settlement negotiations. An applicant is required to establish an intervener fund, which is available to municipalities and other parties, and this fund can be used for retaining expert witnesses, consultants, lawyers, or just used in a way that contributes to making an informed decision as to the appropriateness of the site and facility. The purpose of the fund is to encourage broad public participation. Alle-Catt Wynn's application includes a funding fee of up to $100,000, and notice of the availability of this funding was issued on March 9th, 2022. It should be noted that at least half of the total fund is available specifically to municipal parties, and the remainder is left for other parties. And while funds can be used for legal fees, they cannot be used to legally challenge a decision made by the Public Service Commission. So this slide provides an overview for the kind of beginning timeline of an Article 7 case. First, newspaper notices are published prior to filing the application. Then after an application is filed, in order for the case to move forward, the application must be determined complete. And in this case, the application was determined complete on March 4th, 2022. A procedural conference for this case was held on April 12th, 2022. And public statements like the two scheduled today, one earlier this afternoon and then this one tonight, must be held within 60 to 90 days after the application is determined complete. So this is an outline of the typical steps if a case is going to go the litigation route. First, there will be an identification of alternate routes, and the applicant will pre-file direct testimony along with DPS staff and interveners. In this case, Alle-Catt pre-filed direct testimony on April 28th, 2021. And all parties to the proceeding will file rebuttal testimony responding to the pre-filed direct testimony. There will be evidentiary hearings and site visits as needed, and the parties will submit briefs, initial briefs followed by reply briefs. After briefing, the administrative law judges will issue a recommended decision, and the parties can file briefs on exceptions to the recommended decision. Finally, the Public Service Commission will issue their decision. So now I'm going to kind of go into more detail about the process of a litigated case. The case is broken down into 3 phases. First, the evidentiary phase, next, the briefing phase, and finally, the decision phase. And I wanted to mention that Article 7 was amended in 2020 to require the Commission issue a decision 12 months after an application is determined complete or when the compliance letter is issued. So all 3 phases will need to be completed within a 12-month time frame. However, if settlement negotiations do begin, the 12-month clock is tolled for the amount of time that the parties are in settlement. So giving more of an explanation of each of the 3 phases, first is the evidentiary phase, and this is when the applicant and the other parties to the proceeding present their direct case. The parties will also respond to others in rebuttal, and settlement may occur during this phase. Parties will also exchange discovery requests to gather more information on the project. During the briefing phase, parties will summarize the evidence and arguments presented, and the schedules for evidentiary and briefing phases are developed after settlement negotiations end. Lastly, there is the decision phase. So the administrative law judges will review the information on the record and arguments made in the brief, and they will prepare an analysis of the issues. The judges may also issue a recommended decision, or RD, to the Public Service Commission. The parties will then reply to the RD and can dispute the judge's analysis and recommendations. The Commission will then review everything and issue an order with an explanation of their decision. A party may appeal the Commission's decision within 30 days and seek a rehearing, but only parties to a proceeding can appeal the Commission decision. So in issuing its decision, the Commission is required to make certain findings. This includes the basis for the need for the facility, the nature of the probable environmental impacts, and efforts made to minimize the facility's impacts to agricultural lands, wetlands, parks, rivers, etc. The Commission must also make findings that the facility has a minimum adverse impact on farming operations, whether any part of the project should be completed underground, findings that the project conforms with long-range electric plans, and findings that the project conforms with state and local laws. The Commission can also waive certain local laws or requirements that are considered unreasonably restrictive. So examples of this may be a local law that sets a maximum building height limit that is less than the height of a proposed utility pole. Or another example could be a local law that restricts certain types of fencing or signage that is required around electric equipment for public safety reasons. So local laws such as these can be waived for a project. Overall, the Commission must make a finding that the facility will serve the public interest, convenience, and necessity. In issuing its decision, the Commission has several options. So it can grant a certificate with appropriate conditions, which may include impact mitigation measures or alternate locations or designs. It may approve of any proposed settlement made by the parties, if applicable. And it can also deny application if the facility is not needed or if the Commission is not able to make the required finding. If the Commission does grant a certificate, the applicant is required to provide very detailed plans called the Environmental Management and Construction Plans, or EM&CP. The EM&CP includes everything that is needed to construct the project, and copies of the EM&CP are distributed in the same manner as the application and are subject to review and comment both by parties to the case and by the public. The public can view the filed EMNCP on the PSC website. The Commission must approve the EMNCP and may require additional conditions as well. After an EMNCP is approved, the certificate holder will acquire the needed rights-of-way and property rights, and construction will begin on the facility in accordance with the approved EMNCP. After the facility is constructed, site restoration begins, and the right-of-way will continue to be managed in accordance with the most current long-term right-of-way vegetation management plan, which is approved by the Commission. So you are able to review the Alle-Catt wind energy application online at the PSC website provided here on this slide. Again, the case number for the project is 21-T-0059. There's additionally a guide to the certification review process, links to other Article 7 cases, and the Article 7 regulations on the PSC website. If you would like to file a public comment, there are a couple ways to do so. You can make a statement orally today at the public statement hearing following these informational sessions. You may also write to the Public Service Commission. The address to do so is provided here on the slide. You can email the Commission at secretary@dps.ny.gov, or you can call. The phone number to do so is 1-800-335-2120. When you're making a comment, either by email or phone or writing into the Commission, just be sure to reference the case number, just so that we know which project you are referring to. All public comments will be summarized and posted onto DMM on the PSC website under the Public Comments tab for the case. So thank you so much for joining us this evening and participating in this important project and process.
Thank you very much, Ms. Shaw. We'll take questions on both of our presentations if anyone has them after the next presentation. I'll now turn the floor over to Sean Perry for the applicant.
Thank you, Judge Sayre. Just getting my screen shared here. Alrighty. Thank you, Judge. Thank you to DPS staff for hosting this public statement hearing this evening. Good evening to folks on the line who are able to join us. My name is Sean Perry. I'm the developer for the Alle-Catt Wind Project. Just want to welcome you tonight and present a few slides just to start off this hearing, introducing Invenergy, our project, the team we've got here tonight, as well as our application for a transmission line facility. So Invenergy is the world's leading privately held sustainable energy company. The core of our business is to develop, own, and operate sustainable generating electric sites. Core of that being wind. We've got 100 projects in completion right now that are commercially operating. Solar projects, 43 projects, 16 storage projects, and 12 natural gas facilities as well. We just celebrated our 20th year in operations and hit another milestone of 30 gigawatts worth of sustainable energy produced for the grid. That turns out to about 9 million homes powered with clean, sustainable energy. Headquarters is based in Chicago, and we have regional offices in Ithaca and Orchard Park, New York. Just a brief introduction of the team this evening. I'd like to introduce folks to Rachel Silva. She just recently joined Invenergy December of last year. She is our permitting manager, overseeing all things Article 10 with compliance filings, as well as Article 7, our EMNCP program, as well as local and federal permits. Marguerite Wells has been the lead developer for the project since 2020. She oversees permitting, local development, high-level development, interconnection, everything in between. And John Dax joins us from Hodgson Russ. He is our state permitting counsel. So thank you to Jesse for our slides on the Article 7 program. Article 7 is, as she mentioned, the way or process by which major utility transmission facilities are sited in the state of New York. So similar to Article 10, a one-stop permitting shop overseen by state PSC that takes the place of a myriad of separate state and local permits and approvals. And just to clarify, this only applies to the transmission portion of the Alle-Catt wind project, whereas the facility itself was permitted under Article 10. So our Article 7 application is located on both the DPS DMM docket, as well as our project website, allecatt.invenergy.com, which I'll provide links to. And the application contains project details, studies, and evaluations, as well as maps, technical information on impacts of the project, designs, visual, wetlands and waterways, wildlife, cultural resources, archaeological, noise, and EMF studies. Our application has been deemed complete and in compliance with regulations of Article 10 as of March 4th, 2022, and official proceedings have since commenced. And our case number is here below, as Jesse said, the number 21-T-0059. And to go to the DPS docket, you can enter that case into the dps.newyork.gov, where you'll be able to see filings in real time, as well as proceedings happening on the case. So to participate, I recommend subscribing to the service list. It's a great choice if you simply want to get an email whenever there's a new posting on the DMM website for this case. To do this, you simply go to the DPS webpage for the project, click on subscribe to service list button. This is in the upper right-hand corner of your screen, and you will be subscribed for emails, as I said, whenever a document is filed or there's an update in proceedings on the case. For additional information, the Public Information Coordinator can assist you with interested parties on how to participate and any questions you may have on the process. His contact information is below. His name is James Den, works for DPS. So it's a high-level overview of our transmission facility. Detailed maps on this can be found in our application. Figures 2.1, 2.2, and 2.3 in particular dives deep into each section of the transmission route with detailed drawings, maps, parcels, and vegetative communities. So to turn your attention to the right-hand portion of the screen, the end of the transmission facility is our substation on Osmond Road in Freedom. This is our collection substation, which will be the first stop for the power that is collected from the turbines. This will be sent through a line that will traverse the southern end of the town of Freedom, across several roads, including New York State 98, Osmond Road, Galen Hill Road, Sandbank Road, County Roads 22, 73, and 36, and then cut up into the southern end of the town of Yorkshire, across Blue Street, Cutting Road, Tingey Road, Cageman Road, and finally crossing 16 and ceasing at our point of interconnection substation, which will be built off of Naaman Drive in the town of Yorkshire. Here we will interconnect into the grid, building a substation connecting into National Grid's 345 kV line that currently runs north-south through Yorkshire. As said before, our application is located on the DMM, as well as our website, allecatt.invenergy.com, as well as paper copies found in the following locations: Arcade Free Library, Rushford Library, and Freedom and Yorkshire Town Halls. In the Freedom and Yorkshire Town Halls, we additionally have large maps that are more detailed, and you'll be able to learn more about the particular details of the project there, and in particular, the route of the facility. Additionally, we have several studies that can be found in the application: cultural resources, architectural review, wetland delineations, environmental studies, visual impacts and simulations, noise impact assessments, EMFs, and detailed design drawings, as well as local laws, economic effects, environmental impact, and the location of the facilities, as well as alternative routes explored. So, general timeline for the transmission facility. through the Article 7 process. We filed our application February of last year, 10th of 2021. Shortly thereafter, hosted a virtual open house to inform members of the public about the project. And shortly thereafter, again, approached the town boards of Freedom and Yorkshire to keep abreast local public officials of the project. We received our completeness determination March 4th of 2022, which commenced the Article 7 proceedings. Today we're hosting in April, we hosted a procedural conference with parties to the case. Today, we have the information forum and public statement hearing, and we expect settlement negotiations to run into Q3 of 2022 with a final decision from the PSC in Q1 of 2023. This puts us on a rough timeline for construction of the project in 2024, with the goal of being commercially operating by 2025. Some basic details of the facility itself. There will be 56 structural locations along the proposed route. These are brown weathered steel monopoles for most locations, H-frames where we have specific engineering constraints, and 3-pole structures at route turns. The brown weathered steel monopoles were chosen for their visual impact mitigation. The median structure height is 115 feet above the ground, with some structures ranging above 150 feet, although we only have 2 of those along the proposed route. Spans between structures are ranging from anywhere from 700 to 1,100 feet, with variances accommodating agricultural, geographic, archaeological, and environmental considerations. Again, all these considerations meant to mitigate impacts to farmland, mitigate impacts to wetlands, cultural resources, geographic resources, and the like. We will install a right-of-way underneath the transmission line that will be maintained by Invenergy, planted with a native seed mix and maintained under state regulations. This will be 150 to 175 feet wide. Again, 175 feet being in situations where we require specific engineering constraints. Here we have visual simulation of the structure types. Again, brown weathered steel monopoles. We will, depending on geographic considerations, directly embedding foundations into bedrock or using concrete foundations. There will be 3 power line cables with lightning protection and a steel support cable up top. Here we have the 3 monopole structures, which will be used when we make sharp turns in the route. Again, 3 power cables with lightning protection and a support cable up top. And lastly, here we have our H-frames. These are used leading into turns as the last structure prior to the 3 monopole structure of the turn itself. Again, this is just a visual impact or visual simulation of the proposed structures along the route. The full visual report can be found as Appendix 4F in the application on the DPS docket or on the project website. Below is my contact information, as well as our Invenergy Alle-Catt Wind website, where these slides in this document will sit, especially the application. I encourage folks who are on the call, if you have any questions regarding the application itself, to get in touch with me. It's my cell and email. I'm happy to come out and walk you through the application or email you documents that are particular to your questions. So with that, I'll thank folks, and I will send it back to Judge Sayre.
Thank you very much, Mr. Perry. If you could give the presentation ball back to Ms. Vega and go to the how to raise your hand slide. We have time for questions if anyone would like to ask them. Please understand that this portion of the call is for informational purposes and is not part of the record of this case. If you have a question and you're logged in via computer, Please look for a little hand icon, which is shown on the slide now, and click it. You might have to move your cursor around a little bit. It's usually toward the lower right. If you have a question and you're on the phone, please hit *3 on your telephone right now. We'll identify you and unmute you and let you ask your questions.
We have 3 raised hands. Mr. Hill, go ahead and ask your question. You've been unmuted.
Okay, hi, Sean. I know we've talked several times. I guess I'm kind of disappointed that there isn't more people attending from our town. But the question that I have is, I know that in our different laws that we have, that we've had through the years, starting at 2007 up through 2018 or 19, I'm not sure which one it is. But we've always talked about anything to do with wind turbines, that the wiring would be all underground. And I know that that's what I anticipated for, not only Article 10, but also Article 7. And I guess I'm concerned that, that this option it doesn't look like it's really being taken seriously from our aspect, because we were looking, everybody that I've talked to in our town, whether they're pro for this project or against this project, everybody was saying that they anticipated that everything was going to be underground.
Absolutely. So I understand that, we want essentially to have most of our collection systems underground, and we do have one portion of which where we've got an environmental constraint that goes above ground over, if memory serves, North Road. I understand where you're coming from here. I think that just in terms of the constraints that we're under for the transmission line in particular, we're under pretty heavy cost constraints that come with burying AC current route. I think that would essentially render the project unbuildable just from an economics perspective. And I also think when it comes to how much of the transmission facility should be sited underground, I think we are trying to weigh and pretty seriously here what the impact should be relative to residents visually versus the environment. We obviously cross forested areas, we cross farmland, there are some impacts to wetlands, cultural, archaeological resources. I think that where we could put the transmission facility underground, to mitigate visual impact would also sacrifice the environmental impact as well, and we would be impacting the environment in a much more negative way. I know that was a bit of a long-winded answer. I hope I answered your question there.
At this point in time, I'm not going to argue about that. The other question that I have is, you did mention EMF, and I guess the concern that I have is what voltage are we sending from the substation proposed in Freedom to over in Yorkshire? And the reason why I asked that question is because I know that on, you know, from different studies that I've read and seen, I'm not an expert on EMF. I'm more a mechanical engineer than a electrical engineer. So I guess my concern is how much is the EMF, you know, if it's above ground compared to below ground, and, you know, what type of protection do we have for not only people but livestock from being exposed to the EMF that's going to be produced?
Absolutely. So for electromagnetic fields, we have a study in the application. And I think it's important to just remind folks that we will be complying with New York State's regulations for EMFs across the project, whether it be the transmission facility or the wind facility itself. So in terms of protections, we have going through the application, there's a study in there where we mitigate impacts. And I don't have the numbers off the top of my head or right in front of me based on you know, what the level of EMFs are at the right of way, but they are well below state standards. I think it's important to know that New York State has among the most stringent standards for EMF protection in the nation.
Okay. All right, Sean, I appreciate your answers, and I don't have any more questions, so I will mute myself, and I guess we can continue on then.
Thanks, John.
Could you unmute Ginger Schroeder, please? Go ahead.
Ms.
Sure,
Schroeder,
thank
you've
you.
been unmuted.
Can you hear me?
Yes.
Okay. I just had a question relating to notice. Mr. Hill, who just spoke, who was a Town of Freedom councilman, noted his disappointment that more people weren't attending this hearing. And my question concerns, what are the notice requirements for a public hearing under Article 7?
Well, I am not comfortable sharing exactly what the notices are. I've been assured by our attorney, Mr. Dax, that we've been in compliance with regulations. Although we do agree that broader publication is needed, and we've requested that the PSC conduct an additional public statement hearing. We have notified Judge Sayre about this, and he has indicated that there may be an additional public statement hearing, notice of which will be published and mailed out to stakeholders, including residents of towns of Freedom and Yorkshire.
So I wasn't asking who you notified. I was asking what the requirements are, the regulatory requirements for notice for Article 7. Is anyone able to share that, either at the DPS or perhaps the judge or someone else? I went to look for it and I couldn't find it.
I would say I do not know off the top of my head. If the judge or staff knows, I'm happy to jump in.
Could you promote Mr. Dax to a panelist? Maybe he has an answer. I see his hand is up. Please unmute Mr. Dax. I see you have your hand raised to speak. Do you want to?
Can you hear me?
Yes, we can.
Okay, yeah. So to answer Ginger Schroeder's question, the regulations require notice at certain steps of the procedure, certainly like filing the application is the most important one. The rules do not require that notice be published or provided in any particular way for this public statement hearing. That said, there has been a practice that has developed in Article 7 proceedings in which newspaper notice and mailed notice is provided, although it's not required by the regulations per se. And it's because that practice wasn't followed for this public statement hearing that we requested that Judge Sayer and the PSC hold another hearing in which will be preceded by adequate newspaper notice and mailed notice to the stakeholder list.
Okay, let's move on to the next question. Can you unmute Kip Morrow, please? Or well, okay, call in user. That's fine.
Hello,
you've
can you
been
hear me?
unmuted. Yes,
Yes, we can hear you.
Yeah, this is Eric Muha talking.
Sure, go ahead.
Hello? Yeah, so if I understand you correctly, this is not on the record, this portion of this hearing right now. This is just questions for the presenters.
Yeah, that's right. If you want to make a statement, you'll have an opportunity in the second half of this call. And that will be
Okay, thank you. So with that being said, I do have a question. I appreciated the presentations done by Ms. Shaw and Mr. Perry, and I was hoping that they could email them to me. I can give my email address. It's ericmucha1977@gmail.com. Over.
ericmuha1977@gmail.com. Is that correct?
Correct.
Got it.
Hi,
Yeah,
this is-
absolutely.
Oh, sorry. Sorry, Sean.
Mhm.
This is Jesse. I just wanted to confirm that the last name is Eric. Is it M-U-H-A or M-U-C-H-A?
M-U-C, the C is silent. So
Okay,
it's
perfect. Just wanted to double
M-U-C-H-A.
check. Okay, great.
Mhm.
Yes, I can email the presentation as well.
Thank you. That's all I had for this portion of the hearing. Over.
Okay, thank you. Let's move on to a question from Kip Morrow. You are
Hi,
on.
everybody. Thank you. I guess that last statement raised another question for me. I wanted to make a statement of record. Well, how long would that be? Because I got another meeting starting. How much longer do you think it'll be before you do the record portion?
A very short period of time, and you are fourth on the list.
Fourth on the list?
Yep.
Okay.
You can also participate in the subsequent public statement hearing, which I'm shooting for in 4 to 5 weeks. It'll be another 6 p.m. hearing. Or you can submit your comments in writing by the various ways that the staff attorney has explained.
Yeah, I was on for all that.
If
Well, I'll tell
if
you
you're
what,
running
let
out
me
of
do
time,
this
I can
now.
take you. If you're running out of time, I'll take you first.
I am running out of time. I have another meeting in 20 minutes, and I'm
Okay.
not prepared. So
Yeah.
can I just speak now? And if it's on record, it's not, and I'll submit it in writing also.
No, wait less than 5 minutes, and I'll get to you.
Okay. All right. Thank you.
If those who have asked questions could please press *3 to lower their hands. Thank you.
Or press the hand icon again. Okay, I think we finished the question and answer session, so we're ready to move on to the public statement hearing. Mr. McLean, are we ready to go on the record?
Yes, Your Honor, we are on the record.
Thank you. I call case 21T0059, application of Alle-Catt Wind Energy, LLC, for a certificate of environmental compatibility and public need, pursuant to Article 7 of the Public Service Law. Good evening and welcome. We're here today for a public statement hearing that was noticed on April 27th. This public statement hearing concerns an application, as you've heard, by Alle-Catt Wind Energy, LLC, for authority to construct a transmission line from its approved wind farm to the New York State electrical grid. Immediately previously to this public statement hearing, we had an informational session in which DPS staff explained the process and the applicant gave an overview of the project. But in a nutshell, and for the record, by order dated June 3rd, 2020, the New York State Board on Electric Generation Siting and the Environment granted Alle-Catt Wind Energy the authority to construct, own, and operate a 340 megawatt wind electric generating facility, which I'll call the project. In doing so, the siting board determined that the project will meet all statutory requirements for certification under Article 10 of the Public Service Law, including a finding that the project will be a beneficial addition to the electric generation capacity of the state. The case for which we're having a hearing today is before the Public Service Commission rather than the siting board. It involves the proposed transmission facility interconnecting the planned project to a new point of interconnection that will be built adjacent to the existing Homer City Stoll Road 345 kilovolt line owned by the New York State Electric and Gas Corporation and National Grid. The proposed transmission facility, as you've heard in the off-the-record portion of this call, consists of a 10-mile, 345 kilovolt transmission line and a new point of interconnection switchyard. The transmission line is proposed to connect the project's collection substation to the new point of interconnection switchyard that will be built adjacent to the NYSEG National Grid 345 kilovolt transmission line. The transmission facility is proposed to be located entirely within the towns of Yorkshire and Freedom in Cattaraugus County. The public statement hearings we're holding today are intended for comments on this proposed project. I'm also in the process of scheduling one additional public statement hearing, which will also be a WebEx conference like this one. I anticipate that it will be roughly 4 or 5 weeks from now, and I plan to hold it at 6 p.m. There will be a formal notice from the commission secretary when I get the date set up. Commission will also issue a press release closer to the date of the hearing, and there will be additional public notices that the applicant will make, as you've heard from Mr. Dax. My name is Greg Sayer. I'm an administrative law judge for the Department of Public Service. I'm the assigned administrative law judge in this case. I'm responsible for presiding over the hearings in this case and the development of a complete record in this proceeding. Alle-Catt's wind application is currently before the New York Public Service Commission, which consists of 7 commissioners. The commission may approve or reject or modify the application, as you've heard from Ms. Shaw. We are honored today to have with us on the call today one of the commissioners, Commissioner John Maggiore. Commissioner Maggiore, would you like to make some remarks?
Thank you, Judge Sayer. I appreciate the opportunity to listen to what folks have to say today, and I want to thank everybody who's participating in tonight's public statement hearing. As a commissioner, I find these hearings to be very valuable to better understand the variety of views on items before the public statement hearing. So for that reason, I'm here to listen. You're not going to hear from me again tonight, but I want to hear from you. So thank you for participating, and Judge Sayer, thank you for giving me the opportunity to introduce myself.
Thank you very much, Commissioner Maggiore. I'll explain the process that we're going to follow today very briefly. This is an opportunity to tell the commission your thoughts on the proposed project. Your statements will become part of the case record. We have a court reporter joining us who will prepare a transcript of the hearing, and this transcript will be included in the official record of this proceeding. And when it is ready, it will be available for view on the Department of Public Service website. This hearing is not an evidentiary hearing with cross-examination, and it's not a question and answer session in this portion of the call. It's a forum to hear comments from you. As you heard from Jesse Shaw from the Department of Public Service staff, there are other opportunities for commenting. There are a variety of many other ways that you can get your comments to the commission. And if you could put that slide up for a moment, you can file them directly on the commission's department and on the commission's DMM site, document and matter management site. You can submit them by mail. You can even submit them by phone or by email. Regardless of how they're submitted, we'll give them equal consideration, and we will consider comments submitted throughout the pendency of this proceeding. But we strongly request that you get your comments filed by June 27th, 2022. If you've registered to make a statement, we ask that you please summarize lengthy written statements orally and submit the full written statements by email or mail. But we have few enough people registered to speak tonight that I'm not going to impose a time limit. Let's move right into the public statements. I recognize Kit Morrow. Go ahead and make your statement. Could you unmute Mr. Morrow, please? Go ahead.
Am I on now?
Yes, you're on.
Thank you so much. I appreciate this. My background, I'm a Cattaraugus County legislator, and I'm recently retired from National Grid after 33 years, 19 of which I was in substation construction and switching and also repair. So I've worked around these voltages. Briefly, I'd just like to say the amount of right-of-way needed for 345 line is the 150 to 175 feet. It takes our scenic beauty away. I'd just like you to please consider using underground cable if you can. I do understand the expense, but the visual impact, we don't have much in our county except for scenic beauty, which is one thing. And I wish you'd just consider switching to a underground cable. I have worked with it. I do understand the cost, but I'm just asking once again to consider using it. And then you could use the new right-of-way because you're going to have to lose trees regardless, but use it for grazing because the corona coming off the overhead lines is significant. I understand that New York State does have their regulations and they say they're fine, but I've worked on this for many years, and it does affect things. They say it doesn't, but it does. It does affect livestock. I don't want to get into it because I will submit a lengthier statement and email. But if you could just consider that would be appreciated. And I will submit a much more critiqued statement via email. Sir, thank you for getting me in first so I can get to my other meeting. I'd much appreciate it. Have a great night.
And thank you very much for your comments. Our next speaker is John Hill, Deputy Supervisor of the Town of Freedom.
Mr. Hill, you've been unmuted.
I just wanted to say that, I echo the concerns of the underground line compared to the overhead line. I think from, one of the things that I remember as our Cattaraugus County motto is yours naturally to enjoy. And I do know that being able to see the power lines and things will adversely affect, the living in the area right around that. The transmission lines. I also am a little bit concerned about the EMF. And I'm not an expert on that, so I just know about it. The other thing that I would be concerned about too is, just basically, how do we, go about making sure that everything is done to the exact standard that is specified. I know that we have our town attorney already, and we want to make sure that everything is as safe as possible and as aesthetically pleasing as possible. And to me, that says underground compared to above ground. So that's my comments. Thank you.
Thank you very much for your comments, Mr. Hill. Our next speaker is Denise Willard.
Ms. Willard, if you're on the line, could you please identify yourself by pressing *3? I do not see Ms. Willard, Judge Sayer.
Okay, we'll circle back and try and pick her up toward the end of the hearing. Our next speaker is Ginger Schroeder.
Ms. Schroeder, you've been unmuted. Please proceed.
Thank you, Your Honor. My name is Ginger Schroeder. I'm a resident of Farmersville, New York, which is one of the proposed host towns of the project. I'm also an attorney and a Cattaraugus County legislator, and I represent two of the host towns involved in the Alle-Catt project, Machias and Farmersville. I'm also a member of the board of the Cattaraugus County Industrial Development Agency. I want to say just a short bit about financial interest here. I want to make it clear that I do not have a financial interest in the project, although some people seem to think that I do. My only financial interest has actually been negative since Alle-Catt has sued my household 3 times over this project, and I have provided hundreds of thousands of dollars worth of pro bono legal services to the 3 towns who were involved in the Article 10 proceeding, as well as various citizen groups at various times. I would begin my comments with a procedural observation. The failure to provide meaningful notice of this hearing is an affront to the citizens of this community that have been and continue to be marginalized by the processes employed by New York State in conjunction with renewable development, and in particular with the development of this project. I don't know how many people are aware, but this particular developer signed an Attorney General's Code of Conduct for Wind Development, and the Attorney General did an investigation of citizens' complaints and actually cited this company for their failures to have transparency. The AG found that Invenergy failed to meet its obligations pursuant to the code, and that the code was established in order to avoid conflicts of interest or even the appearance of conflicts of interest. I always found it very interesting that if people are telling me that I have a conflict of interest when I have no financial interest in the project, yet those with financial interests in the projects, Invenergy has been hiding them and hiding these issues. I was on the earlier call just listening because I was interested in to see how many people actually appeared for that call. And, you know, it's interesting. People want to know who the leaseholders are, and yet those forms have not been filed in the Cattaraugus County clerk's office. And I think they should be filed right away. I think it should be required that Invenergy files them right away so that everybody knows who has a financial interest in the project. The Article 10 proceeding in connection with this project was also rife with complaints of improper notice of proceedings. So going back to the notice issue, these types of irregularities and lack of transparency make citizens skeptical of government and cause many to believe that there is an improper agenda being pushed. After all, legitimate agendas do not need to be hidden. I've received comments from my constituents as a county legislator that were upset by the lack of proper notice for this public hearing. How can it be a public hearing when the public is not notified? In our legislature, when we have a public hearing, or in our IDA, when we have a public hearing, we actually notify the public. This morning, I received a message from the president of a citizens group of about 300 members who only found out about the hearing last night, and I had to tell him he was too late to sign up for today's hearing. On the earlier hearing, I was glad to hear the judge open it up to anyone who was on the line. But I will tell you, the written instructions for this hearing made it crystal clear that if you did not pre-register by 3 p.m. on Monday, you might as well, you weren't going to be able to speak. So I don't think anyone will necessarily be on, or very few people will be on to share that. I'm glad that you're going to do an appropriate notice and get the kind of public participation that is really appropriate in these type of proceedings. As to my substantive comments, in 2016, the PSC approved the final supplemental environmental impact statement addressing the impacts of the Clean Energy Standards 50 by 30 goal, which was 50% renewables in New York's power sector by 2030, since replaced under the CLCPA with a 70 by 30 goal. However, I would note that no supplemental EIS was completed for the CLCPA goal. How can this be? The potential burdens of overhead transmission lines on communities hosting these large-scale renewables is acknowledged in the GSEIS as significant. I quote, meeting the 50 by 30 goal, and now we know it's a 70 by 30 goal, through the addition of renewable power sources will have significant impacts on some communities. As these large-scale renewable resources are added, there may also be some changes to community character and viewsheds resulting from addition of transmission lines. The specific nature of the potential community impacts will be evaluated in site-specific proceedings following implementation of the CES. I believe the current technology makes avoidance of this burden feasible. For example, with few exceptions, all electrical collection lines for the Alle-Catt generation project have been ordered to be installed underground. And I think that's very clear, both for local laws and all of the citations to that decision. The residents will already have to bear the viewshed burden of up to 120 600-foot industrial wind turbines littering the beautiful enchanted mountains of Cattaraugus County. This project is incompatible with the comprehensive plan of Cattaraugus County. Our county planning board so held, but unfortunately they have no say in the matter. Our county should not also have to bear the additional burden of above-ground transmission lines. For these reasons, the commission should order that Alle-Catt's transmission line be installed underground, unless the applicant demonstrates that doing so at any location is not feasible. I don't think we should have to hear about the cost. There are lots of subsidies being offered for this project. We've never actually been able to see what kind of money this private developer is making on this project, so I don't think that the public should have to take the applicant at its word, especially since the applicant's word has not been very good, and we have an AG violation that says so. Decommissioning. I note that the lack of proper decommissioning plan, and I would hope that that issue would be addressed in this proceeding. Roads. Last, as a county legislator, I'm concerned about county roads. There are 3 county roads that I can see that are involved in this proceeding. We are an economically challenged community. Many of our roads are not in good shape. The county is currently negotiating a road use agreement with the applicant, but only with regard to potential impacts on roads resulting from construction of the wind energy facility. The agreement under negotiation at this point does not protect county roads from damage related to the proposed transmission line under consideration in this proceeding. Exhibit E6, Effects on Transportation, in my view, fails to adequately address what corrective measures Alle-Catt will take in the event that damage occurs to county roads during the transport of heavy equipment, materials to the project sites, other than referring to some sort of maintenance and protection of traffic plan, which will be prepared in the future. The applicant references the use of road use agreements on page 2 of this exhibit, but as I've noted, I don't think at this point we have any sort of RUA in process under negotiation that would protect against those issues. Thank you for the time that I was allowed to speak.
And thank you very much for your comments. Let's circle back once more and see if Denise Willard is on the line. Ms. Willard, if you are with us, please hit *3 on your phone and we'll unmute you.
Ms. Willard, can you please, if you are on the line, can you please press *3? I see a call-in user. I'm going to unmute and see if it's Ms. Willard. Good evening. Is this Ms. Willard?
Can you hear me?
Yes, we
Yes,
can.
we
Can you hear me?
Yes, we
Okay.
can.
All right. So my name is Denise Willard. I am a Freedom resident. First, I would like to begin by talking about, for the record, the failure of Invenergy to provide public outreach and notifying the area residents about this public hearing. There was nothing. No public notices were posted in the local newspapers and no notices such as postcards or letters received in the mail. Unfortunately, it justifies the common suspicion we all have held concerning the lack of transparency by this billion-dollar company, Invenergy, and New York State. I would also like to remind everyone that many people in our area do not have virtual access, including me. I tried to sign on, and you guys were giving a presentation. I couldn't see anything. I tried signing on. I registered before 3 o'clock yesterday, and I can't see anything. And according to what came up on my computer screen, which is in and out, I had to pay $3.99 to download WebEx. But anyways, I wouldn't have known about this public hearing before being today had it not been for a concerned citizen alerting me to this hearing. I'd like to note that I have several concerns, but was not given adequate time to research them all, as 3 days, when you consider life and all that goes with it, including an emergency visit to the vet and all that goes with it, to go through all the documentation and highlight all the things that there are issues with. My first concern is with the wetlands. There are 22 pages in this exhibit, and 16 of those, there's 16 of the pages show the transmission line going straight through the middle of wetlands. I mean, Invenergy didn't even try to avoid the wetlands. I'd like to know, were the Army Corps of Engineers alerted to any of this? My next concern, and I have to, I'm just going to summarize it because there's a lot and I have to put it in order and I didn't have time. But I'd like to request that a tree conservation plan be a part of the conditions, because I mean, you're cutting down how many mile of transmission lines at 175 feet, 150 to 175 feet. I mean, these are carbon absorbing trees and we're supposedly concerned about CO2. My third concern is I request that Invenergy provide a decommissioning plan, as there is nothing on the record for decommissioning. I'd also, my fourth concern, and like I said, I'm going to summarize this and submit it, which I've already submitted a public comment about not being notified. I want to make sure, and that's been noted by other people, that the transmission line is buried underground. Living here in Cattaraugus County, what we rely on is the beauty. I just attended a horse show not that I could ride, but the name of the horse show is, and it's at the Cattaraugus County Fairgrounds, the Enchanted Mountains Horse Show Series. So we want to keep that plan. For my fifth concern, I'd like to request that a property value guarantee agreements for all landowners without a lease within 1.5 mile radius of the transmission line. I mean, when you have a project like this that only a few benefit, not that I would want to hear whether it benefited me or not, that's kind of sad. My sixth concern is I'd like to request protections from stray voltage. And I mean, we heard from a gentleman that worked on electric lines, and my husband is an electrician, and he gets an electric shock in the winter and he just about jumps out of his wits, because if you've been shocked before, you know it. And there are people within this town in Freedom, and they're farmers, that have had stray voltage on their farm. So you can't tell me that these transmission lines or the turbines themselves don't give off stray voltage. We need to protect the people in the town. That was my sixth. Okay, my seventh concern is how is Invenergy gonna request, or I mean, how is Invenergy gonna handle complaints? There needs to be a system as to how Invenergy handles complaints. I feel like we're being kind of like left behind, and and ignored, not only by Invenergy, which, I mean, it's kind of sad when their maps are unreadable, but you can be intimidated by going to a public meeting and having Scott Johnson point to a map and show you where you live, like you're being creeped on. My eighth concern is the communication systems. The transmission line will cause interference with our radio, TV signals, and phone and cell phones, which, I mean, service is spotty as it is. And my ninth concern is I'd like to request further protections for the farmland and the agricultural lands. I mean, we live in a right to farm community, and we need to protect the land that we live on. I have a feeling that all this so-called renewable energy is actually destroying the planet, because I firmly don't believe that any man-made structure is going to save the planet. And I'm happy that you are going to have another public hearing, because I tried alerting people and some people didn't get the message until today. And by today, they couldn't, I let them know that they could still attend the meeting, which I had to do by phone, but they wouldn't be able to speak. So I hope that you will be kind enough to let us know when that next meeting is scheduled right away, so we can get flyers out and alert people of that public meeting. I think those are my comments. I'm really not happy, but those are my public comments.
Okay, thank you very much. Thank you for those comments.
Sometimes we feel like we're speaking to the wall.
I can tell you that the preferred date that I have, don't put this on any flyers yet, and you know, don't start telephone trees. But my preferred date for the next, for the additional public statement hearing would be at 6 p.m. on June 28th, using this same kind of mechanism. It would be set up so that you can either log in on WebEx or call in as you've done. It will also be live streamed on the Department of Public Services YouTube site, which can be accessed from the main webpage, dps.ny.gov. So keep June 28th in the back of your head. That's my preferred date. I'm not sure that that's going to be the final date, but there'll be plenty of notice.
Okay, thank you.
That is the complete list of people who have registered. As I did this afternoon, I'm going to throw the floor open to other people who are here either on computers or on the line, and give them an opportunity to speak even if they did not register in advance. I will start with people who are participating electronically. As I mentioned before, you need to find an icon on your screen that looks a little bit like a hand, usually around the lower right of the screen. Move your cursor around to make it appear. Click on that. By the way, if you've already spoken, please click on that now so that you can unraise your hand, and we'll see the new people who are raising their hands for the first time. So at this point, if you want to speak, please click on that raised hand icon if you're on the computer.
I see Eric Mooch. I'm going to unmute him.
Yes, hello, can you hear me?
Yeah, Mr. Muha, go ahead.
Yeah, thank you for your time. I'll make this brief. I just have 8 requests that I'd like to make. For the record, I request that the transmission lines be buried underground for the entire length of the transmission route in order to preserve the rural characteristics of the area. Second request, that there be a decommissioning plan. Third request, further setbacks from wetlands, historical buildings, recreational land, tourist areas, campgrounds, and also to protect the residential views as well. Third request, protections from the impacts on communication systems. Fourth request, to create a complaint management system to have Invenergy outline specific mitigation procedures. Fifth request, protections from stray voltage. The next request, protection of farmland. And the final request, that Invenergy have a conservation plan to replace each acre of trees that would be removed from the 10-mile transition line route. Over.
Thank you very much. Does that complete your statement?
Yes, thank you.
Okay, thank you very much for your statement. I will now go to people who are on the telephone who have not spoken yet but would like to speak now, even if you did not register in advance. If you'd like to speak, please press *3 now on your telephone and we will locate you in our list and unmute you. So please press *3 now.
Good evening, you've been unmuted. Would you like to speak? Please identify yourself. Thank you.
Yes, I would. My name is Mark Heberling. I'm a resident of Farmersville, New York, one of the proposed host towns for the wind project. I'm also the deputy town supervisor for Farmersville. I've heard my name was called at the 1 p.m. conference for the public hearing. I'm very sorry about that, but I thought I was signed up for the 6 p.m. hearing. Somehow I got my signals crossed. Frankly, I did not know about this public hearing until 2 days ago. Invenergy attends every town board meeting in my town, and I would have thought that they would have notified our town board. This was the exact same experience we had in the Alle-Catt Article 10 process, very lax communications with the community. The sense is they really do not care. They tell everyone this project is a done deal. These statements are repeated by the developer to anyone who will listen, and has disenfranchised many residents who would otherwise like to participate and be heard. But the thought is, why bother? I'm sure that is exactly what they want. My main and really only comment has to do with the enormous burden this community will have to bear with this project. Our view shed and our beautiful scenery will be destroyed for my whole lifetime and a lifetime of many others. So many extraordinary large industrial wind turbines, very few residents. The leaseholders will receive direct financial compensation for this burden. The very least the DPS can do is require these transmission lines to go underground. One less visual assault on our community. The potential burden of overhead transmission lines on communities hosting large-scale renewables is well known and has been publicly acknowledged in the GSEIS. We are told it is significant. The Commission should order that Alle-Catt's transmission line be installed underground unless the application demonstrates that doing so at any location is not feasible. Also, decommissioning. I note that the lack of proper decommissioning plan and would hope that this issue is addressed. Also, I would like to comment on a statement that I heard Councilman Hill, Deputy Supervisor of Freedom, stated that he was concerned that these are not being buried. I again piggyback on his comment, and I am surprised by Sean Berry's comment about that it's cost prohibitive to do the right thing. Well, I would offer that maybe this project is poorly sited and not engineered in a proper manner. Thank you for your time and allowing me to speak, Your Honor. Thank you.
Thank you very much for your comments. I think we have one more request. Is that right, Ms. Wasser?
I believe so. I'm not sure if this is old or new, but I'm going to unmute. Good evening. If please identify yourself if you would like to make a statement or have you. Hello, good evening.
I think it may be someone who spoke before.
Okay.
The last call for speakers, either press the raised hand icon or dial *3 on your handset.
I do not see any additional speakers, Judge Sayer.
And speak at the next public statement hearing, which I'm hoping will be on or about June 28th. I want to remind members of the public that they may submit public comments throughout these proceedings by the other means that have been described a couple of times and in the notice of public statement hearing that was issued on April 27th. Again, we request but do not require that you submit your comments by June 27th. I thank the commenters for your participation. I thank Commissioner Majori for participating, Jill Wasser and Xenia Vega from our Consumer Services Office for administering this session, and our court reporter, Anthony McLean. Before I go off the record, one more last request. Are there any further requests to make comments at this time? Hearing none.
Do not see any, Your Honor.
Thank you. In that case, this hearing is concluded and we will go off the record.
Off the record, Your Honor.
Thank you very much, everyone. Have a great evening. Please stay safe. We will